Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Like many people, I've been watching the Johnny Depp and Amber Heard trial, not because it's really important for Canadian law, but it's an interesting trial, and I hope it provides an example that maybe expands people's notions of what domestic violence can look like, and maybe breaks some of the traditional stereotypes. But one thing that's come up, and particularly during Johnny Depp's testimony, is hearsay objections. There's been quite a few of them, and enough, in fact, that we see this little exchange where he gets a little bit testy about them.
When is Miss Heard's birthday?
22nd of April.
And in 2016, how was Miss Heard celebrating her birthday?
We'd set up a dinner for her, which was, she wanted to have a dinner with her, with all her friends, and Josh, Drew, Rocky's boyfriend, who was some sort of chef, he asked her what she would like for him to cook. That's hearsay, I guess.
Yes. I'm not just sure it's offered for the truth of the matter, sir.
He got it.
Okay, all right, well then.
I'm learning.
There you go.
So what you can see here is Mr. Depp is a little frustrated. He's been interrupted several times with hearsay objections, and he's pushing back. He's doing so with a sense of humor, but he's pushing back. Now, hearsay is also an objection that quite commonly appears in courtroom dramatizations, TV, movies, etc. And that's because it's very recognizable. Lots of people know that hearsay is an objection that you can raise in court, but they may not understand what hearsay is. And in fact, it's kind of tricky. It trips up law students. It trips up lawyers. It can be kind of difficult to parse out. So I thought I'd talk about what is hearsay, why are there so many exceptions to it, and how this can impact you in terms of a lawyer trying to decide what to do in practice. So to start out, hearsay is a statement that's made out of court that is then offered in court in order to prove the truth of its contents. Now, I know that sounds a little dense, so I thought I'd break it up with some examples. Let's say I'm in court and I am testifying that my friend Bob called me up and said, hey, it's my birthday, I'm having a party, we've got food, we've got booze, come on over. Well, that's an out-of-court statement, right? Bob is not, we're not asking Bob, we're asking me, and I'm talking about Bob here. So there are non-hearsay purposes for that. Let's say I'm only offering that statement to explain why I'm driving down a particular road at a particular time. At that point, the truth of the statement doesn't matter. Like, it doesn't matter if Bob is lying about the party. Maybe he's telling me that he's having a birthday party and instead he's got, 6 guys there with baseball bats and they're going to beat me up and rob me. Well, doesn't matter for this purpose because I'm only explaining why I was on this particular road at a particular time. But if we consider instead the possibility that we're trying to prove that Bob actually had a birthday party, at that point, it matters whether that statement is true or false. And so it's being offered for the proof of the truth of its contents. That would be a hearsay purpose for that statement. So that would be objectionable. Now, you might say, well, why is this? Why can't I just say, hey, Bob said this stuff? And one of the big things is just what I was talking about, is in terms of whether or not that statement is true. Because let's say Bob is lying to me and I go into court, I'll be able to testify very confidently about what Bob said. But I'm not going to be able to tell you necessarily if Bob is lying, and I can't be effectively cross-examined on this. So this is a situation where we can essentially end up with bad information before the court. Also, I'm in court and I've been, I've sworn an oath. I'm potentially under penalty of perjury, but Bob's out of court statement is not made under oath. So, Bob can't suffer any consequences for, perjury or obstruction of justice or anything like that if he was lying to me. That also lends to the possibility that by allowing hearsay evidence that we might end up with, falsehoods being presented to the court. The court can't, they can't observe Bob as well to see if he's lying or anything else. So what the court wants is the best source of the evidence. If we want to get in that Bob is having a party, we should call Bob. Bob should come in and testify as a witness, and then he can directly say whether or not he was having a party or not. So that's, that's sort of the basics of the hearsay rule. Now, there's all sorts of exceptions to hearsay, and this is because there's all sorts of places where statements that would otherwise be hearsay are things we probably want to have come into court. And so one of those examples, just is government documents or, business records. So let's say, I want to show activities in my bank account. Well, the way I do that is by bringing in bank statements, which are a statement. I mean, that's what they're called, but they would still be a statement that's made out of court. But we have a business records exception to the hearsay rule. And those business records are, once you fall into one of the traditional exceptions to the rule, then that statement becomes presumptively admissible instead of hearsay, which is presumptively inadmissible. I know this is getting a little bit complicated, but all of these exceptions have one sort of common thread, and that is the principles of necessity and reliability. Now, necessity basically means that there isn't really a good way to get this statement in except through tendering the evidence that would otherwise be hearsay. So when you think about the bank records, if I want to show the activity in my bank account, if I'm not allowed to bring in those bank records, how else does this get in, right? Who would be able to testify as to what was going on there? And the other thing is reliability. Remember all those problems I was talking about in terms of what if Bob is a liar? Well, bank records are probably going to be accurate. They've got a, responsibility to make sure that they're accurate. The whole business of the bank is going to be, contingent on them keeping accurate records. So it's less of a concern in those circumstances. But that doesn't, we've got several other exceptions, and you can think about whether or not these ones equally fall in and how they weigh on the necessity and reliability issues. So another exception is dying declarations. I show up at a scene, I hear, gunshots, I go running towards the gunshots, and I find a guy, he's lying on the ground, he's bleeding, and he says, "Bob shot me," and then he dies. Well, that's really important evidence in the sense of, if we're trying to prove who did it, the court kind of wants to hear this. But when we think about necessity, we can't bring the dead guy back to life to testify. He's not available anymore. And in terms of reliability, well, what motivation is he going to have to lie as he's laying there bleeding to death? But there are still potential reliability questions in the sense of, if he had survived and was brought into court, we might ask him questions like, how do you know it was Bob? Wasn't it dark out? You got shot in the back. How do you know it was Bob? And, if we were able to cross-examine him on those things, he might say, well, I guess I'm not that sure. I just assumed it was Bob because we had a fight 2 hours previously, and I don't really know. So we run into problems because that dying declaration is going to be taken as really strong evidence, notwithstanding the fact that it might not be the strongest evidence if it actually were to go into court. The other thing, or another exception that can raise some potential problems, is one we call res geste, and I hate using Latin. The sort of non-Latin for it is a spontaneous or potentially an excited utterance. And so what that means is, let's say I arrive at the scene of a fight, and, somebody who is there who is surprised by this and who's agitated by it says, oh, well, the guy in the red hat started it. He punched the guy in the blue hat. And I don't, and please don't read in anything. I'm just picking random colors out of the air. I'm going to get a political argument in my comments here. But, you know, let's say that person then runs off and is unavailable to testify. If the court finds that this was an excited utterance or, you know, a spontaneous utterance, that might be considered an exception to the hearsay, because that guy's not available. He ran off and we don't know who he is. He's the only person who's there who actually saw the fight. I know this is a somewhat artificial hypothetical here, but, you know, they might say that statement is necessary because we don't have that person there, and reliable because it was driven by emotion, by the sort of flow of what's going on. But again, you know, we can't cross-examine this person to know how accurate they are, whether they got a good view of it, whether they're relying perhaps on double hearsay, like did this person actually see it, or did they just hear about this from somebody, you know, another person who did see it. So hearsay gets to be a little tricky, and some of the exceptions that were raised in the Depp and Heard trial, or some of the objections there, seem proper to me. There's one moment where Johnny Depp is testifying as to what his doctor told him, and the other side objects to that, and that's probably proper, because if they want to get those medical details in, they should probably subpoena the doctor and the medical records and all of that. But some of them maybe not so much. But yeah, hopefully this has been helpful to you. Hopefully this is a useful overview. Hearsay can get really complicated. Now, in terms of in practice, one of the things that this means is that when you're thinking about trial preparation, you have to start thinking not just about what statements and what facts do I want to get in, and what statements and facts do the other side want to get in, but also how are they going to be brought into court, and which witnesses do you need to bring? You know, do I need to subpoena Bob? You know, I can't just, you know, come in and testify myself. I actually have to get Bob there in court. And if there's some reason why Bob can't be there, I might need to document that in order to establish the whole necessity angle if I'm going to try to use that statement anyway. And the case law on that gets a little complicated. I'm not going to do a full deep dive through the case law in this video, but there can be a lot of debate over that. But you also want to pre-think about what the other side might bring in as evidence and where you might want to object, because it's necessary, if you're doing trial work, that you be able to think on your feet and object when it comes up. But it also helps if you've thought a bit about this and about what objections you need to watch for. So this is it's an interesting trial to watch. They've got, you know, high-priced teams on both sides. It's a civil trial, so it's not really my usual thing, but yeah, it's interesting to watch, and it gives me an excuse to talk about hearsay. Sadly, we don't have a whole lot of courtroom video from here in Canada. So yeah, let me know in the comments below whether you think I've explained this sufficiently. It's always kind of hard to gauge, because I'm coming at this sort of explaining things from a lawyer's perspective, but I'm hoping to make this accessible to non-lawyers. That's really the goal, is to spread legal education and legal knowledge, and that doesn't work if I'm only providing explanations that only really kind of work to me. So let me know if I have explained that clearly, and yeah. Thank you for watching. Please like this video, share it with your friends, subscribe to see more content. I also want to thank my Patreon supporters. There's a link to the Patreon below. At the $50 level, Canada's National Firearms Association, the CCFR, the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited and Marc-Olivier Damour. And at the $20 level, Peter Hilger, Mark, Jane Babe and Luxor, Haywire, Dale Nesbitt, Cameron Johnson, Bruno R., Andrew Elsich, and Rick J.D. Thank you as well to the $10 supporters who will be in the crawl immediately following. Thank you to my supporters on Locals as well. That's another way to offer support if you don't like Patreon and YouTube, which some people tell me they don't like them. So there's another way to watch and to support. So thank you for watching. Again, I hope that this has made things a little more clear, and see you next time. I thought I'd just add in one more thing, which is that it's possibly hearsay when he's asked, when is Amber Heard's birthday? He clearly wasn't there when she was born. I mean, that'd be real creepy. So he would have heard that from somebody, probably her. Of course, the reason why no one objects is because, first, it doesn't really matter if he's right if that's her birthday, so it's debatable on that one. But also just, as a matter of practicality, nobody cares. This trial doesn't hinge on when her birthday is, so this is one of those objections you might say, well, I could object here, but I'm just going to let it slide because there's nothing to be gained from it other than maybe ticking off the judge a little bit. Anyway, just thought I'd add that in, and cheers.